It's now moving to Mauro. We are going to have some specifics on the Brazilian perspective and his experience in dealing with such cases. Mauro, you can start your presentation.
Thank you, Rafaela. First of all, thank you for the Instituto Dannemann Siemsen for having me today. Great pleasure to be here with you, Bence, Patricia, and special thanks for the audience as well. In my presentation, I will use some slides, so I will share my screen with you. Just a second, please. Okay. So,
okay.
Yeah, okay.
Let me jump in and make the first question. Mauro, what are the specifics of trade dress protection in Brazil, and so generally speaking?
Well, yeah, first of all, I'll give you a general overview about the subject. Starting again, yeah, I know that you mentioned this before, but starting again with a definition about trade dress. Trade dress is essentially the overall look and feel of a product, packaging, or service that identifies its source. So is a source identifier. It can encompass a wide range of elements, including, and that's important because it's trade dress is complex exactly because of this wide range of elements that can be encompassed. So, in related to the product itself, trade dress can encompass the shape, the overall configuration of the product, design, decorative elements, patterns, or motifs of the product, color, unique color, a combination of colors, texture, the feel of the product surface, in materials, the materials used in the product's construction. So, the packaging instead of the product can also contain a lot of trade dress elements. Shape, again, the configuration of the packaging, design, graphics, images, or text of the packaging, color, typography, the fonts used in the packaging, and again, materials. So you have also service-related elements. So not only products, but service can be subject of trade dress protection. Services, you have mainly the decor, the overall ambience and design of a store or restaurant, maybe the menu, the appearance and layout of a menu, uniforms, and advertising materials. And finally, we can also consider as part of a trade dress sounds, unique sounds associated with a product or service, and also scent, a distinctive smell, fragrance linked to a product or service. So, Brazil, like many other countries, lacks specific protection for trade dress, legal protection for trade dress. Trade dress infringement lawsuits can involve copying of products, labels, packaging, and even the look and feel of stores, among many other things, as we saw in the beginning of this presentation. Parts of the elements that composes a trade dress can often be registered. That's important to say. As Bence mentioned this in his presentation. You can have protections as a trademark, industrial designs, copyright, but registration is not necessary to sue someone in Brazil based on trade dress infringement. But the fact that we don't have specific legislation here makes us to have to rely on broader legal concepts. And among them, I point out to two legal provisions that are important. First is Article 5, Item 29 of our Constitution, that says that the law shall ensure the inventors of industrial inventions and temporary privilege for their use, in addition to protection of industrial creations, ownership of trademarks, company names, and other distinctive signs. This is the important part here. The Constitution affords or has protection for any other distinctive signs. This is a broad understanding, and you can understand that trade dress is protected under this definition, part of this definition. Article 1953 of the Brazilian Industrial Property Law is also very frequently mentioned in a trade dress infringement action. And this section of our law says that a crime of unfair competition is committed by he who uses fraudulent means to divert for his own or a third party's benefit another's clientele. So these are the basic two elements that you have. And I add a third one here, that is section 10b(2) of the Paris Convention for the Protection of Industrial Property. This international convention applies to Brazil as well. And the convention says that any act of competition contrary to honest practice in the industrial or commercial matters constitutes an act of unfair competition. So this is basic, the legal framework that we have here. And before I go to some specific cases, I would like to mention that we, in preparation for this presentation, we ran a case law search, but not focus on the merits of the decisions, but instead on identifying the main sectors of the economy in Brazil, the main sectors here that are involved in trade dress litigation. And we ran the search before the Superior Court of Justice database, and also before the some Court of Appeals database. And we try to identify companies from litigations involving these companies over the last 10 years. And the results, as you can see, show that in most of the trade dress litigation cases, we have the cosmetic and personal care industry involved, or the food industry involved, or the pharmaceutical industry involved, or still the beverage industry involved. These are the main players in Brazil in these actions. We also identified not the same level as these four, but also other important players. And I mentioned here the gas station segment, toys, apparel, household appliances, and cleaning products.
Mauro, yes. Can you comment specifically on trademark litigation in Brazil?
Yes, I was about to start making some comments about some specific cases. I will start with this case involving backpacks, and this was a decision by the Superior Court of Justice in Brazil. The Superior Court of Justice is our court of last recourse for infraconstitutional matters. And in this case, plaintiff was Oakley. Oakley filed this lawsuit against Wise Comércio to seize backpacks imported by Wise, claiming they copied the trade dress of its products. Oakley's lawsuit was initially dismissed for lack of a registered trademark on industrial design, but Oakley filed a successful appeal to the São Paulo Courts of Appeal. The Court of Appeals recognized that the protection of a product's trade dress doesn't depend on formal registration, and the court found that Wise Comércio had unlawfully copied Oakley's trade dress and awarded damages to Oakley. Wise, in turn, Wise Comércio, the defendant, in turn, filed an appeal to the Superior Court of Justice, arguing that because the products were seized by the Brazilian customs and never reached Brazilian consumers, Oakley couldn't claim any damages or moral injury. In the decision, the Superior Court of Justice first reaffirmed its position that trade dress is protected even without a prior registration obtained before the Brazilian Patent and Trademark Office. The reported justice in this case highlighted that trade dress is protected regardless of any registration by Section 5, Item 29 of the Constitution, the one that I've just mentioned. and also based on the unfair competition provisions of the Brazilian IP law that I also mentioned. In addition, this decision reaffirms the principle that in case of IP infringement or unfair competition, damages are presumed. This means that proving the illegal act is enough to establish material damages without the need to demonstrating actual losses. And lastly, and important, the Superior Court of Justice in this case set an important precedent by expressly recognizing that moral damages can be presumed and can be awarded in case of trade dress infringement or unfair competition in Brazil. That was the first case. The second case that I would like to mention is this one, is another special appeal, an appeal to the Superior Court of Justice. This one was decided by the third panel of the Superior Court of Justice. And this case, Ipera S.A., the owner of the Engov blister and trademark, filed a lawsuit against Laboratório Catarinense LTDA, claiming that the packaging for post-drink copied the look and feel of Engov, leading to confusion and undue association. Laboratório Catarinense, in turn, claimed that although both products used the blue and yellow packaging, they displayed different trademarks, and therefore there was no unfair competition or confusion. Laboratório Catarinense also argued that since colors in themselves cannot be subject of exclusive rights under our industrial property law, the company could not be held liable simply for using similar colors. The trial judge decided that Laboratório Catarinense had engaged in unfair competition, concluding that there was a risk of consumers' confusion or association. Accordingly, the judge ordered Laboratório Catarinense to cease any use of the post-drink product and pay material damages. Laboratório Catarinense appealed this decision, arguing that the marks were different enough and that the colors can't be protected. The São Paulo Court of Appeals upheld the lower court's decision, but did so by a majority of votes. And because of that, Laboratório Catarinense then appealed to the Superior Court of Justice, and then the appeal was accepted for examination and judgment. So the third panel of the Superior Court of Justice examined the case in detail and found that Laboratório Catarinense intentionally copied the Engov package, and in doing so, the panel said that, concluded that both products competed in the same market. The Engov product was on the market first, and the trade dress of the Engov was widely recognized by the consumers. The court, in this case, pointed that the difference between the marks post-drink and Engov, both registered before the Brazilian Patent and Trademark Office, was not enough to prevent confusion and association between the trade dresses. The court concluded that the plaintiff's Ripera's product had a solid reputation in its segment, and therefore its consumers purchased the product mainly based on the overall trade dress appearance, and not specifically because of the mark Engov itself, which it is a well-known trademark in Brazil, but even so, according to the court, the public was much more used to buy the product based on the overall impression of the trade dress instead of the mark. So that was a summary on this important decision. But interestingly, the same panel of the Superior Court of Justice, in similar case involved Grandene versus RS Calçados, involving these sandals here, adopt a different position, upholding the lower court's decision in which the court of origin found that there was no risk of consumer confusions in the sandals regarding the trade dress of each product due to the prominent presence of the respective manufacturer's trademarks on the sandals they produced. and because the appellant's trademark is a strong distinctive sign in the consumer's market. So here, Ipanema it was considered a strong and well-known mark in the sector. But in this decision, contrary to the other, the court understood that the mark had played an important role in this litigation and considered the products likely to coexist. So this is to show how subjective in nature is a trade dress litigation, and it's difficult. We can find decisions in different directions. Finally, a third case that I believe is interesting to talk about is this special appeal involving the owner of Neutrox and the owner of Tratex to do two trademarks in the shampoo field of business in Brazil. In this lawsuit, JF Participações, owner of the Neutrox product, claimed that Dragão Química Ltda, owner of the Tratex hair product, copied the Neutrox trade dress, formed by its cylindrical shape, yellow color, and red cap. The trial court ruled in favor of JF, but Dragão appealed and won in part. The Court of Appeals applied in this case, and that's interesting, the 306 degrees test, which I will talk a little bit more in a few seconds, and decided that Dragão was not engaged in any act of unfair competition. JF appealed to the decision, arguing that the court made a mistake by not following the Brazilian law on trademarks and unfair competition. The special appeal filed by the JF was unanimously dismissed by the third panel of the Superior Court of Justice. But the judgment emphasized the importance of the 306 degrees test, and this is a test that was created by two lawyers here in our office, Dannemann, Felipe Cabral and Marcelo Mazzola. They proposed this test in an article a few years ago, and the test has been adopted in several cases involving trademarks. And now the interesting thing is that the courts started applying the test also in connection with trade dress cases. This test, so this is the 306 degrees test, helps to determine the similarity between trademarks and trade dress. And the test consists of factors such as how distinctive the trademarks are, how similar the trademarks look and sound, the reputation of the alleged infringer, how long the trademarks have coexisted in the market, the type of products involved, the target market, and whether the trademark has been diluted. Well, based on this test, the Rio de Janeiro Court of Appeals decided that there was no unfair competition by the owner of Tratex, a decision, as we saw, subsequently upheld by the Superior Court of Justice. In light of the above, the reporting just pointed that a reevaluation of the matter was inadmissible, and as I said, dismissed the special appeal from JF. The court also ruled that the plaintiff's claim was barred by the principle of laches, as they waited over 40 years to take legal action. This is one of the killing arguments raised by Tratex, exactly that the products had been coexisting in the market for over 4 years. Just a few years ago, Neutrox started a litigation and trying to bar Tratex, the company, from using Tratex because of trade dress infringement. But of course, after 4 years of peaceful coexistence in the marketing, the court ruled that this wouldn't be possible. And the court also highlighted that the time, in addition to the time of coexistence in the market, dilution also apply to this case because several other players or competitors in the market, in this specific market, were using more or less similar trade dresses involving cylindrical packaging and same colors. So the overall appearance was diluted. So the decision here was against the plaintiff.
Mauro, do you think there are any other relevant factors that you think it would be interesting to comment on?
Rafaela,
regarding these cases?
Rafaela, just before, can I tell the audience that they are free to ask questions in our chat?
Oh, sure, yeah.
Only to let them know. I'm sorry to interrupt, but only to let them know. Please feel free to make asking to the lectors in the chat. Thank you.
Okay, Rafaela. Yes, I think that there is one additional issue that deserves to be mentioned here today. And this issue has to do with expert analysis in cases involving trade dress. Well, judges still decide a considerable number relying on their own perception to determine if there is a risk of confusion. However, the Superior Court of Justice has ruled since 2017 that experts' testimony is necessary to prove trade dress violations. And here I will mention two decisions in this regard from the Court of Appeals. First, one from the third panel. The third panel in the decision, a special appeal published in 2017, ruled that the confusion that characterizes unfair competition is a factual issue subject to technical examination in order to verify the market in which the good or service is inserted, and concluded that the denial of technical evidence replaced by experience as a substitute for evidence is a conduct that restricts or may restrict the party's right to defense. So this was the third panel, a decision from 2017 from the third panel, and then we have a similar one, more detailed, from the fourth panel of the Superior Court of Justice in 2018. In this one, the fourth panel of the Superior Court of Justice decided that the overall image is complex, talking about the case itself, and comprises of various elements. In the absence of specific legal provision and given its non-registrable nature, determining whether imitation has occurred and constitutes unfair competition must be assessed on a case-by-case basis. Expert input is crucial to evaluate market factors, consumer behavior, advertising and marketing strategies, the level of attention of the average consumer of the product, the product's launch date, and other distinctive features of its presentation. So again, emphasize the necessity of having experts input in these cases. And these two decisions were followed since then by several others from the Superior Court of Justice. Therefore, we may conclude that the denial of a request for experts' testimony in trade dress infringement actions can be considered a denial of defense, which has led to the annulment of judgments and decisions. And therefore, and thus, it is recommended that experts' testimony always be requested in this type of action.
Yes, any final thoughts, recommendations, suggestions, anything that you would like to share with us in your experience and cases that you have been involved with?
Yeah, just a few conclusions based on the case law research that we performed and on the presentation of Bence as well. Trade dress protections in Brazil has some specific issues and difficulties. First, it's complex. We have a difficulty in defining trade dress because of the broad elements involved, and the trade dress has a complex nature and makes it challenging to define and protect. Second, case-by-case analysis. Each trade dress case requires a specific analysis based on its particular circumstances, making it difficult to establish general rules. Third, we have this issue, balancing competition interests. Courts must balance the rights of trademark owners and trade dress owners with the need to promote competition and innovation. And finally, now, as I mentioned in the end of my presentation, role of experts' testimony. Experts' analysis is crucial in asserting the complexity of trade dress issues and providing a technical foundation for judicial decisions. So I think that these are some important elements to have in mind. And with this, I finish my presentation. Thanking again for your patience and for the audience to have followed us today.
No, thank you guys for sharing with us your experiences. And yes, it is not easy to talk about trade dress. I'm pretty sure that everybody here has different approaches and results, and sometimes we think that it is a case that we will win, and it isn't something that happens. So we have some questions in the chat. The first one for Bence. It says, trade dress copies are very common in Switzerland. One of the biggest supermarkets here has traditionally copied trade dresses of other brands throughout the years. Nowadays, besides Migros, also Lidl and Aldi, these are very famous supermarkets, are big on copies. How have you been dealing with these cases in Switzerland in the past? As a consumer, I am usually also looking for the cheaper option with similar trade dress. Bence, could you share the UK study you mentioned with us? So first question is, how have you been dealing with cases in Switzerland in the past? Yes.
Thank you for the questions. I saw the question. I've started to think about Switzerland, and I don't remember a specific case in Switzerland actually in the past few years that we have worked on. But what I do know is also based on the question that it shouldn't be very different from the rest of Europe in the sense that unfortunately some parts of Europe are kind of notorious or known for lookalikes, and quite often these would be, as Anna also mentions in the question, retailer lookalikes. And when we deal with retailer lookalikes, it's highly sensitive, and careful consideration must be given to the fact that we have a business relationship with the retailer as well. So whilst we address the issues that we have, they are addressed with consideration and using the good relationships we have with these companies. So I think the sensitivity there is rightly pointed out with those retailers that are mentioned. Yes, the reaction as well to looking for the cheaper option. I think it's legitimate in a cost of living crisis or in a difficult economical environment that we have in I think many countries of the world. It's legitimate, but also you have to draw a line as to how much you are relying on others who have built their branding over the years, and how much you're relying on them to win over consumers. So there's an element in that I think we all feel a little bit who work in these cases that is kind of not right and crosses a line. So there's no problem with cheaper alternatives if they don't sort of hijack some of the intellectual property. And yes, I can share the study that I mentioned, and if possible through Rafaela or Patricia, I can email, and then it can be requested from the Dannemann team.
Great. Then we have a question for Mauro, and that's it. I realize that due to the absence of specific legislation, we have to use broader legal principles. Do you think we could apply the Consumers Code for trade dress disputes in Brazil? And if yes, what would those principles be?
Well, the Code of Consumers Protection has a specific provision that deals with the protection of IP. I think that is section 4, item 6 or something like that. And because of that, we have a specific provision here that applies. And as a general principle, yes, as well, because we as a whole, if you have any act that is likely to prejudice the consumer, we can apply the basic principles of the consumer protection law as a whole. But we have this specific provision. I believe that's Article 4, item 6.
Yeah.
So it is. So yeah. So that's something that can be used together with the notion of unfair competition and the sections that I mentioned about the federal constitution, the IP law. We have other provisions that you can apply as well. For instance, unjust enrichment that is established in section 884 of the Civil Code is another one that you can apply. And actually, if you have protection for parts of your trade dress, as for instance, as a 3D trademark or industrial design, or even copyright in elements, we can also apply the copyright law and the industrial property law, specifically regarding trademarks and industrial designs.